it, take him back. We'll call him out later. Take it back. You keep laughing. You laugh one more time, that's 30 days. People versus Thomas Styron. Here we go.
Mr. Public Defender of Otello on behalf of Mr. Styron, who stands to my left. Well, let's talk to the judge about that. Right?
We've been through this. Seems to be some confusion.
What's the confusion?
I've stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you charged with, sir?
So, I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding,
You understand, first of all, that if you do indeed direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up.
what? She's got another case. Okay. You told me she was done.
Here, what? Oh, they're there. All right. First calls the case of the people versus Styron. Recall. State your name.
My name is Thomas Styron. I live in man.
Mr. Styron, you are before the court. You have elected to represent yourself. I do have to advise you that you have 3 counts against you. The first count is that of fleeing and eluding 3rd degree under the motor vehicle code. Do you understand the nature of that charge, sir?
This is under the assumption that you're compelling me to identify as Thomas York Styron, the legal entity on this case.
I believe that you are. Do you understand the nature of the charge, sir?
What you're watching here is a classic sovereign citizen style courtroom argument. The defendant is trying to draw a distinction between himself as a living person and Thomas Styron as what he calls a legal entity or strawman. This is a well-known but legally baseless theory that claims a person's legal name represents a separate corporate fiction that the government can be billed against, while the flesh and blood individual is somehow exempt from prosecution. Courts uniformly reject this argument. It has no basis in actual law. Notice how the judge doesn't engage with the theory at all. He simply repeats the charge and asks if the defendant understands it, refusing to validate the legal fiction framing. This is standard practice. Judges are trained to not get pulled into these arguments and instead just move the proceeding forward procedurally.
I don't understand how the name you have on the case and who I am, it's 2 different people.
I have a complaint, Thomas Styron II. Do you understand that that individual is charged with fleeing and eluding 3rd degree?
So,
Do you understand the nature of that charge? You just need to answer my question.
for the record,
Take him back, and when he decides he wants to cooperate, we'll bring him back, maybe. I'm not threatening you. Say one more word, and that's 30 days. 30 days.
this one.
Recalls the case, people of the state of Michigan versus Thomas Styron II. Mr. Styron, you are before the court on a felony complaint that does allege count one. And I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on 3 charges. Count one is the charge of fleeing and eluding third degree. Under the Michigan Motor Vehicle Code, that is a felony punishable by up to 5 years incarceration or $1,000 fine plus court cost, and would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count two is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court cost. Count three is a misdemeanor offense of operating with a license suspended, denied, and or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court cost. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. You are also entitled to be represented by counsel at this and all subsequent proceedings. If you could not afford to hire an attorney would be provided.
Here, the judge is walking through the formal requirements for allowing a defendant to represent himself, what's called a Ferretta-type warning in many U.S. jurisdictions, ensuring the waiver of counsel is informed. He's explicitly telling Styron that self-representation means no help from the court, and that he'll be held to the same procedural and evidentiary standards as a licensed attorney. This protects the proceeding from later appeal claims that the defendant didn't understand what he was giving up. Right after this serious warning, Styron interjects with another sovereign citizen phrase, calling himself a beneficiary, not trustee. This refers to a theory involving trust law, claiming the government holds some kind of secret trust account in the defendant's name. Again, it's not a real legal concept recognized by courts, and the judge simply ignores it and continues with scheduling the preliminary exam.
At public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, you would be entitled to counsel. It is, as we have gone through the previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself. I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings and will hold you to the same standards that I would hold an attorney representing or practicing before this court. So, with all of that, and with the court's understanding that you do not want to be represented by counsel, I will set this matter for its next proceeding.
You understand I'm the beneficiary, not trustee, right?
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if they turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odetella. Thank you, sir.
Thank you. Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Styron. I tried to speak with him and go over it, but I'd be happy to turn that over to him at the first available.
All right. If you would either turn that over to the court officer so that they can provide that to Mr. Styron so that he has some discovery. And if you could do that today, I would appreciate it.
Yes, Your Honor.
I'm setting the preliminary examination. Thank you, sir.
Yes.
The people would have their witnesses available June 11th. Set this matter for preliminary examination in person, June 11th, 2024, 9 a.m. That is before me. If defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. Defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said, I'm
So first of all,
This final stretch shows the consequences escalating. Styron continues invoking sovereign citizen language, talking about trust fraud, refusing to acknowledge his social security number being tied to the case, and accusing the judge of impersonating him as someone he's not. The judge responds firmly, warning him that further disrespect will add more time to his sentence, and reminding him that he will be held to courtroom conduct standards regardless of his personal legal theories. What's notable is the judge never debates the substance of any of these claims. There's no engagement with strawman or trustee arguments because legally they don't require a response. The contempt charge and added days are the real enforceable consequences here, while the ideological arguments remain just noise from the court's perspective. The hearing ends with bond continuing and the case held over to the next date.
watch your
Beneficiary, you're
language.
treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a cess QV trust matter involved in this? Is my social security number attached to this at all? Go figure.
Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up.
You're
You will
presuming that
you will
jurisdiction
learn
over
how
the
to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to
disrespect
compel me to be somebody I'm not.
or this
You
institution.
have no evidence
It will not
to prove that
happen.
I'm who you say I
You
am.
will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
Very good. You'll serve the 30 days. We'll see. We'll see him on the 6th. Bond continued.